All right. Hi, this is Tim Blankenship with Divorce661.com. We're experimenting with some live videos. You can thank Ask Amanda for this idea. We do plenty of videos throughout the week and year. We probably have over 900 videos now, I think, on Facebook and YouTube. But we want to start doing some live video here and talking about some common mistakes when filing for divorce. And we're hoping that the live videos pick up some more viewers. And I know many people do not need our help, but you probably have friends that might be going through divorce in California and need some help. So we're going to be talking about common mistakes when filing for divorce. We're going to talk more about procedural issues. Hey, Robert Montoya, how you doing? Thanks for joining us. Appreciate you supporting us. But we're going to be talking about common mistakes and mostly about form preparation and initial filing. We're talking about the summons, petition, and initial paperwork that gets filed to establish your case with court and to get a case number issued. So in doing so, we get a lot of people who come to us. I'd say probably 50% of our business comes to us from people who have tried to file their own divorce case, and for one reason or another, their case was rejected. And a lot of it has to do with issues that they run into when filing their initial divorce paperwork, because how you start your divorce paperwork, how you file your petition and initial paperwork with the court is going to determine how your divorce turns out. And you can actually have your judgment rejected for issues related to how the petition was filed. So this will be interesting because this is our real first live video, and I'm trying to read the comments and notes at the same time, seeing who's joined us, but we're going to get into it right now. So here's number one, and we had some people email in some questions. If you have questions, feel free to just ask away, and I'll try and catch your question live here. But we had some questions emailed into us, and then we just have a list of some common questions that come up. So let's talk about the petition and initial paperwork. Hey, Juan, how you doing? Thanks for joining us. So names must match on summons and petition. Here's an issue that comes up quite a bit. When people file for divorce, there's 3 or 4 forms you're going to file. Specifically in California, they are going to be your petition, your summons, and if you have children, it's going to be a form called the UCCJEA or FL 105. And then there's a procedural document. The most important thing to do when you're filing your summons and petition is to make sure that your names match on the summons and petition. So what happens is people will either handwrite their summons and petition, filling out the paperwork, or they will type it out online. So when they're listing themselves as the petitioner or the respondent, what they'll do is they'll put, for instance, Tim Blankenship petitioner on the petition, and then they'll put, say, Tim S. Blankenship, or first, full, middle, and last, or a different name. The names that you use for the summons and petition, first of all, need to match, and second of all, they need to be consistent throughout the remainder of your paperwork. So it's important, again, to have the name of the petitioner and name of the respondent the same exactly throughout as a summons and petition. So that's number one. Number two, confusions, and again, we're still talking about the petition. Confusions on the date of separation or not putting in a date of separation. So I get the question a lot, hey Tim, I'm filing for divorce, but we're still living together. So what do I use as the date of separation? So generally what will happen is someone will have their judgment rejected, and it'll be an issue because on the petition, something they filed several months before, they never listed a date of separation. It is required. Date of separation can be something such as the day you moved out, the day you started sleeping on the couch, or a lot of times it's just the day of filing. If there's no previous date that comes to mind, a lot of times it's just the date we're filing. So confusions on the date of separation, you're going to want to put down a date of separation one way or another. It needs to be on the petition. Moving down the list on issues with the petition specifically, we notice a lot of people that file their divorce will list property on the petition, and they're kind of setting you up for failure because on the petition it does say, please list your community property, please list your separate assets and debts, but they give you about 2 inches of space. It's common practice among our service and just the legal industry and profession in general not to list property on the petition except in certain circumstances. And I'll go over those. But generally speaking, you're just going to want to say to be amended, that the property is going to be addressed later on. That's how we handle all of our cases. Now, the one of the cases you are going to want to list property on the petition, and by attaching your property declarations, is if you know it's going to be a default case. If you know the other party is not going to participate, you're going to want to list the property on the summons by attaching the property declarations, which is the FL 160, because when you file a default judgment, the only thing you can ask for in your judgment is what you asked for in the petition, and if you don't list any assets or debts in the petition, you can't ask for any in your judgment. So if you know it's going to be a default where the other party does not agree or is not participating rather, you're going to want to list all the assets and debts in the property disclosures or declarations and attach it to your petition. All right, moving on down the list, I have a note here. Understanding that what you request in the petition, okay, we just talked about that. Trying to terminate spouse support on long-term marriages. Okay, this is kind of a bit convoluted here. So when you're going through a divorce, you will have the opportunity to decide whether or not you want to have spouse support or not. And there's some rules that you have to follow. If you have a short-term marriage, say less than 10 years, then you can waive spouse support either by default or by agreement. But if you've been married for longer than 10 years and it's by default, the courts will not allow you to terminate spouse support on a long-term marriage by default unless you file what's called a prove-up and asking the court for a hearing to explain your rationale for terminating support on a long-term marriage. Generally speaking, if it's by default, you're going to be required to have your spouse support reserved for future determination. But if you are in an uncontested divorce case in California, you'll be able to waive spouse support if it's waived by both parties. Okay, requesting a name change on the petition. So one of the things you'll be able to do by filing your petition or in the judgment is you can request to have your maiden name restored. And even if you don't request it in the petition, this is what I tell my clients. If you're not sure, go ahead and request it in the petition. You can even put it in your judgment. It doesn't mean you're ordered to do it immediately, but you will have a judgment in your possession. So say 10 years down the road, maybe after the kids have grown and you want to change your name back, you would have a court order already to do so, and then you don't have to file a legal name change to do that. Okay, let's see what else. Okay, now we're going to talk about the summons. Summons is a pretty easy form. Again, the petition is one of the forms initially you need to file your divorce case. The summons is the next one. It's an easy form. You just need to put your name at the bottom and your address. It's pretty straightforward. If you're representing yourself, your name will appear. You will be representing yourself, and where it says name of attorney or self-represented litigant, that's going to be you. All right, let's see what else we got. Okay, UCCJEA. So again, we're talking about you're going to have the summons petition, a jurisdictional form, and if you have children, there's going to be a UCCJEA that needs to be filed with the court. What they're asking for is they want to know where the children have lived for the last 5 years. So a couple of things here. The kids need to reside in California, and you need to have a California address on the UCCJEA if you're going to ask the courts for to make determinations over the issues of custody in your divorce, which obviously if you have minor children, you're going to want some sort of custody order. If that's the case, you need to have a California address for your children. And where people who are trying to do their own divorce run into trouble is they will list maybe the parties live in California and one of the spouses lives in another state and the kids are living there. They will file their petition with showing the kids living in another state, and then when you go to turn in your judgment asking for a custody order, the court's going to reject your judgment and say they do not have jurisdiction to make issues or decisions over the issue of custody for your children because they do not live in the state. So we've seen that as a problem. However, let's say that you and your spouse have separated. You certainly can list, and let's say the children are living with you 50-50. You can put that 50% of the time they're living with one party and 50% of the time they're living with another party. All right, so that was pretty much the summons petition and some of the same issues that I see coming up on a regular basis. But let's talk a few other things that come up on occasion. If you have issues with your initial summons and petition, you get one shot to amending your divorce summons and petition, and you would just mark the amended box. What people do is they'll file their summons petition, and let's say if they have children, so they're filing the UCCJEA. If you go to amend your summons and petition, and again, you only get one choice or one time to do that. If you go to amend your petition, you have to amend all the forms, meaning you don't just amend the petition, you have to amend the summons petition and any other initial documents you filed initially. Again, you only get one chance to do so, and if you mess up the second amendment, or the first amendment rather, your second filing, the courts, at least in LA County, are requesting or requiring you to file what's called a request for order to get a second amended petition filed with the court. So that handles issues related to amending your petition. Let's see what else we have here. Okay, we covered that. And that's pretty much it. So we have talked about in this video here, we talked about that the names must match. I'm going to do a quick recap here. Names must match on the summons petition exactly, first name, middle initial, and last, or first name, full middle name and last, whatever you use on the summons petition. Make sure that you use that name throughout the divorce case. You do need to put a date of separation on all of your filings and on your petition specifically. If you have not separated from your spouse, it's just going to be the date that you filed. Don't list your property on the petition necessarily unless it's going to be a default case, in which case you're going to want to use the property declarations. Understanding that what you request in the petition, okay, this goes to the default. If you're going to have a default case, you need to list your property on the petition. The theory being, if it's a default and the respondent is not appearing, that they have obviously been, yeah, thanks Dave, I'll repeat that middle part. Appreciate that. If they have filed the petition, then the default, if it's going to be a default case, the property needs to be listed on the petition. Again, the theory being they didn't respond because they're in agreement to the petition. Trying to terminate spouse support. Okay, we talked about that earlier. The spouse support in a short-term marriage can be terminated on a short-term marriage by default. It can also be done by agreement on a short-term and or long-term marriage. So we've covered each of these 6 points pretty exclusively, and then I did a quick recap of them. My name is Tim Blankenship with Divorce 661. We do handle divorce cases anywhere throughout California, and we try and specialize more in the amicable type divorce cases. You know, it is divorce, so it's not like you guys are going to be, what they say, unicorns and rainbows all the way throughout. But if you have at least agreed with your spouse that you want to try and get through this without attorneys, without the high cost of litigation, and you think that either sitting with me or sitting, the two of you sitting down at the kitchen table, or even with perhaps some third-party mediation services, that you guys can end up coming to an agreement, then you wouldn't need an attorney. It would certainly be something that we can take care of. So I appreciate you guys tuning in. We are going to try and do this on either a weekly or twice-a-week basis. We'll see how this turns out and what kind of folks we have coming to these live videos. But again, just trying to provide as much content as possible to help people who are trying to get through divorce without an attorney do so. Tim Blankenship, divorce661.com. You can go to divorce661.com for more information, or just give us a call at 661-281-0266. And if you're just tuning in, we will put this as a replay on Facebook and on our YouTube channel. Thanks so much for watching, and we'll talk to you next time.